one is now in session.
Yeah. Thanks. Please be seated. Oh, good morning. We're on the record in our CV 220717, Windschill versus Windschill. As you know, we record and live stream these proceedings, so please give your name and the name of your client before you begin. You each have 20 minutes per side, although you're not required to use all of your time. We do require you to keep track of your own time. And keep in mind that we've read the briefing, studied the record, and just conferenced this case this morning. So, Mr. Berkshire, you may proceed. Good morning.
Good morning. May it please the court, Keith Berkshire for the appellant Daniel Windschill. The main issue that we have in this case for our appeal is whether or not the trial court properly looked at all of the applicable statutes in this case versus each other in doing the analysis. Our main contention is that under 25-40302 and 25-103, that those have to be read in conjunction with 25-408 in coming up with the result in this case. And this is, the generic statutory guidance in this would be impari materia about reading statutes together and so forth. Beyond that, 25-40302 specifically references that it has to be read with 25-40302. It references 25-403, which of course is part of 25-408. So our contention here is that the trial court didn't properly analyze the two possible outcomes of this case, the two possible parenting scenarios. And there were only two, which was both parents in Phoenix or dad in Phoenix and mom in South Dakota. Mom unequivocally testified that if the court denied the relocation, that she would move back to Phoenix. However, the trial court didn't analyze it that way. They analyzed it as if mom was going to stay in South Dakota without the children.
Well, because that was her, without the children?
They specifically, one of the court's findings states specifically that if father was primary in Phoenix.
Well, he didn't even ask to be primary,
did he? He never did.
Okay.
That's my point, which is that the trial court analyzed as if mom was not going to be primary. Mom was always going to be primary under both situations. Here, father, knowing that his limitations due to his residency program, he didn't petition for equal parenting time. One of the few in family court that doesn't petition for equal parenting time, even though they know they can't exercise it. He petitioned for what he thought he could exercise, which was 3 days a week. However, and in doing that, that was what the court should look at, was what happens in scenario A, which is both parents together in Phoenix, or scenario B. And that's where we think that the legal error here occurred, that the only one of those scenarios that meets the statutory guidance is scenario A with both parents in Phoenix.
Does the court have to weigh one against the other when the request that the parties brought before the court was a relocation request? So the idea that one of the parents says, look, if this is denied, I'm not going to go. Doesn't the court have to reach the petition that got in front of the court, which was to relocate, and then up or down, thumbs up or down based on all the statutes as you argue on that question, as opposed to saying, well, I know she's going to stay here, wink, nod, so I don't really have to take a hard look at her request to go to South Dakota because I know she'd stay here and it's just easier that way.
Well, I think they have to look at what the result of granting it or not granting it is. And so,
but within the confines of the statute, though, because that's the request, is I don't want to be in Arizona. So when you say that it's somehow outside of the statute that the court has to look at what the effect is.
Well, but again, some of the cases that the parents go no matter what. Look at Whiten, the main relocation case in Arizona, which was one of mine. Mom went no matter what. And that was the testimony in that case was that she went no matter what. And so that is a different end result than whether I go, I'm only going with the kids, which was the testimony here, which is why I think that they have to look at the scenarios.
That's not a factor. It's looked at in light of the best interest of the children. But the idea that the practical effect of this, whether someone would stay or wouldn't stay, where do you find that in the statute that that's something the court has to weigh differently in a relocation case where the parent says, if you deny this, judge, I'm actually going to stay?
there's not a factor of the in 408 of whether or not they're going if you grant it. I agree with that. However, that's why you have to read the possibility that when the court looks at parenting plans. So under 25-40302, when the court is statutorily required to look at the parenting plans and the effect of these parenting plans, that's where we're saying that the court's error came into place, is that under 25-40302, you have to look at which of the options satisfies the statute. And so 40302 requires the substantial, meaningful, and frequent parenting time, which the court only stated one of the factors, which was substantial, didn't look at the other two. Or words in that statute, I guess you want to say. And so that's the difference, is that's the gist of our argument. We're not arguing some factual, the court weighed the evidence wrong or things like that. We're arguing that 40302 has to be read with 408. So that when you're looking at the two options of what the potential parenting plan is, they have to meet all of the relevant statutes here. And there's only one option that meets the statute, which is the both parents in Arizona. Again, if this case was, mom said, I'm going no matter what, I'm not coming back, I don't think we have much of an appeal, frankly, because it truly was picking between dad being primary or mom being primary. But that's not what this was.
So aren't you asking mom not to make the concession that she'll move back here? I mean, her admitting that I'm going to be with my kids no matter where you, court, decide that they're going to live is basically her saying, the kids are my paramount importance to me. I'll deal with the consequences should you find against me, not I'm giving up my request to move to South Dakota.
Well, I think that's why the courts, every CLE I think I've ever been to says that that's why the courts always consider this the $1 million question, are you going to go? Because it affects that. And so like in Wharton, where the mom was, I'm going no matter what, it changes the dynamic, because the court has to look at the end result of what these parenting situations are. That's what, when it comes up with a parenting plan, it looks at, again, 25-103 is just a public policy statement, but 25-40302 is not. 40302 is a statute that says you have to look at whether that parenting plan that you implemented is frequent, meaningful, substantial parenting time.
So how does it change the court's calculus if mom said, I'm going to South Dakota, that's where I'm going to reside? How does it change the way the court balanced the factors, etc., in this case?
Well, I think, again, it determines that it always has to look at the two parenting plans. 40302 says that each party submits a proposed parenting plan. The court then has to weigh those two against each other for which one satisfies the statute, which one satisfies the words out of the statute that talk about the frequent, meaningful, substantial parenting time. One of the issues here, too, is that, the court we allege that it didn't do that. It cites to a 1995 case, Pollock, which was pre all of the statutory changes under 408. It was pre-103, it was pre-40302, and it only used the word meaningful. When you look at the Pollock case, which was this court, it says that whether the relocation allowed for meaningful time. That doesn't meet the new statute. And in Baker, the Division 2 talks about how, all of these changes after 2010, when all of this stuff went through, it was 2010, was the 103, then 2013 was the change of the wording to 25-403, where we got rid of, which parent was primary. We went to the past, present, and future relationship of the kid, with the parents with the children, was that in Baker, Division 2 talks about how it's clear that the legislature intended that parenting time, whether there was frequent parenting time with each parent, that's the overriding factor. That's where the legislature has gone with the statutory changes. It hasn't gone the other way.
But Mr. Berkshire, I'm a little bit confused about the fact that if we go your way, are we saying that anytime a parent says they'll stay, that the court has to weigh that differently, and that somehow they can't, even if they find, as under our standard of review, it certainly looks like the court in this case considered the different scenarios and the fact that she could stay and what that would look like here and what that would look like for your client's parenting time. But are we saying then that if a parent is willing to stay and that really there's some sort of heightened burden now that the court really, if they allow a relocation under a scenario where the parent has agreed to stay, and of course that would impact the party who's not asking for relocation, their parenting time. Just being in town versus not being in town. So it would be like we're making another standard that I don't see in the statute. And so help me understand how ruling, as you're saying we should here, doesn't have the effect of what I just said.
Under Wayton 2, which is the MEM decision, it says there's not a heightened standard. So even though we won it and got the relocation overturned in Wayton 2, this court said there's not a heightened standard, that there's not a difference of a clear and convincing versus preponderance. My point in this is the court has to look at reality. A lot of relocations are no choice. They are going. They have I've done a bunch that were military deployments or other things like that where you have it. Our point is the court has to weigh between the two options which one is back up. Relocations for a job. I'm in the military. I have to move. My company transferred. I had a client that, when U.S. Airways shut down, they got moved to Dallas. They had no choice. That relocation, the court had to look at the reality. They are not coming back because they will be unemployed. So I think that is our position, is that while there's not a heightened standard, the court is obligated to look at the reality of the two possibilities in weighing which one is in the best interest. If the court has to pick a parenting plan under 40302 that's in the best interest of the kids, they have to analyze what's the circumstance under both possible scenarios. There are a lot of people that want to go to a different location, usually back to where grandparents are. When they get divorced, a lot of people, go home. But the court is obligated to look at the two realities. They can't ignore that one of the realities does meet the statute in the best interest prongs, where the other one doesn't.
Well, what about the scenario where someone has to move? You've got two fit parents, as I think this case clearly states. There aren't any concerns about anybody's fitness. And you've got someone who's got to go, and they both ask for primary. So they both have the ability to have primary, they both ask for primary, there are no fitness issues, and all the court has are these statutes and these factors to weigh, and we have an abuse of discretion standard. How would you ever be able to say that that decision stands when you've got to pick one or the other, and they both want primary, and they both everything else is equal. They're both going to have some child care involved, they're both going to have family near them. I mean, everything is equal down the middle, but the court still has to make a choice. And so obviously allowing someone to move or to stay is going to affect the statute that you're implicating in 40302, saying someone's going to lose out, a fit parent is going to lose out on some meaningful, substantial parenting time because the other parent has to move or wants to move, asks the petitions to go. What would happen to those cases?
That's Wayton 2, where the court said no relocation because the burden is on the party. The court in that situation, this court 4 months ago, did exactly that when it reversed the trial court, who found that almost all the factors were equal. This court didn't send it back. They said, no, that was not enough to prove a move. The burden is on the person trying to move, and therefore, if everything is equal, you've got two fit parents, everything's great, the person moving loses.
But didn't this court, in your case, find differentiation, and don't we have to defer to that under our standard of review?
Well, you defer to factual findings, not the legal conclusions based on them. Here,
right.
The issue was that they didn't apply they have to look at the two scenarios. There's no way to not look at the two scenarios. You have to say what happens if relocation is granted or not. That's just the reality of the situation. What happens if they go to school A versus school B? And that is the situation in these cases. And so in that scenario, Judge Bailey, where you're talking about they have to move, the court has to look at those two situations and see if the statute is applied correctly. And here, the court didn't look at the two situations. Specifically in the findings, they stated that, dad can't be primary. Well, dad never wanted to be primary.
Right.
So we're saying that under a scenario where they have to move, job, something, military is unfortunately a really common one that we deal with this in, is they look at the two situations. And in that case, because of the way the legislature wrote this, that the burden is on the party trying to relocate. If everything's equal, they don't get to.
And what about the finding this court made about the fact that even if the children stayed here, that your client's ability to have parenting time, I think, I don't remember the exact wording, but basically is no better because of the schedule that your client can't control, given, but that the opportunities to drop into a baseball game or to have a little more time here or there, that the court did weigh that, and I guess that's where I'm having a little bit of problems with
Well,
your-
I think, again, reading the findings on that, the court didn't go through and say, they didn't say if mom moves back, here's the benefits, versus if mom moves, here's the benefits. The court didn't do that, and that's the main basis.
Okay.
However, that gets into, again, our distinction between the three words in the statute. What is substantial versus frequent and meaningful, okay? I mean, I can come up with, somewhat idiotic scenarios here that I can give you parenting time every day from 7 a.m. to 2 p.m. when your kid's in school. So from a purely numeric time under the substantial, which is what this court used, I can add it up and it seems like a lot of parenting time, but you get 0 because your kid's in school. I can give you, 11 p.m. to 6 a.m. as well, and you could have almost equal parenting time, but you actually never see the kids, so it doesn't meet the frequent or meaningful. Here, you can't say that 1 week a month is frequent versus 3 days a week. You can't say that it's the same thing. And again, that's where the court used only the substantial, this quantitative versus qualitative analysis. The real issue is, again, and not to cite to a MEM decision, but because of Waiting 2, since Waiting at least 1 is kind of the main precedent here on this, is that's what the court looks at, is like you have to look at the reality of what each scenario was better. And it's not just purely math. You got 6 factors, dad got 5 of the 25 403 factors, or plus 408. You have to weigh them against each other, and which scenario, relocation or not, satisfies the statute. And that's our position, is that you have to compare them. There's no way not to compare them, because it's the same thing if the court says any decision-making or other parenting time issue they have. They look at which essentially is better, which scenario meets the best interests of the kids and which doesn't. And in that, that's why this question about whether somebody would leave is always, never can say the number of CLEs I've been to that they say it's the $1 million question. I mean, if judges ask it, if one of the parties didn't, are you going to go? Because it makes the situation, that's how they weigh the two situations. Okay, this one, I want to go here versus here, or if both parents were relocating, what's the scenario? They have to weigh the scenarios versus each other. And one of the things, we put in our brief, was the weighing of parents versus grandparents and cousins and so forth. I mean, this court in Borla, maybe I'm mispronouncing, but it was pretty recent, talked about, that, again, parents win over grandparents, and a lot of the precedent in grandparent cases is stuff my firm's done, where it's, parents win. Okay, the idea of grandparents and so forth versus the parents, okay, they're going to see the grandparents less if they don't move to South Dakota. Yeah, well, they're secondary. And, those types of concepts. The other issue is this concept, the court seemed to get stuck on childcare. This court in Barron, which the portion of the case that didn't go to the Supreme Court, which was the custody portions, because only the military stuff went to the Supreme Court. This court in Barron's like, look, the reality of a divorce is people use childcare. Mom might have to get a job. This is what you guys said, not being sexist. Mom might have to get a job, dad might have to have childcare. That's the reality of the divorce here. And to essentially hold that against my client versus somebody being in childcare versus seeing his kids 3 days a week, and that's the scenario that the court has to look at. And so the court seemed to put extra weight. I get that under 403 there's the factor of any other person that's involved with the child, et cetera. However, when you come down to saying, well, the kid will see the cousins less and the grandparents less in this situation versus dad, that isn't an equal playing field. Dad wins. Whether they see the grandparents and cousins ever again, dad wins.
And how do you factor in the fact that mom will have to get full-time employment if moving to Arizona, whereas she doesn't and works part-time there and has childcare built in that doesn't cost?
Well, and I think that's what this court said. It goes back to what this court said in Barron as well, that's the reality is people have to do that, and that's just implicit in a divorce. And again, it seems this wasn't, I think it's a different situation for a job. Mom didn't have what you'd say a job you'd typically move for. Okay, we get into these cases with Intel where they moved to Portland because they got some huge promotion and so forth. Mom is pretty, I'm not trying to degrade her, but they were like a front receptionist and I think she was cleaning houses part-time. These weren't like jobs that somebody would typically relocate for as some dream job. It just happened to work. The problem with that is it penalizes, it's what you're asking Judge Campbell, it kind of penalizes a parent that has to have a job. I mean, most people have to work. Most people use childcare. And so saying that again, those things and grandparents win over dad seeing his kids, those aren't on equal playing fields.
And I don't think that was my point. To my point, okay, so mom in Arizona is full-time employed and the kids are in childcare full-time, as opposed to mom is employed part-time and gets to spend more time with the children in South Dakota. How does that factor into your analysis?
I think in the two scenarios, it still goes back to which parent, the overriding concern under 40302, the frequent, substantial, meaningful parenting time. And so
moving to Arizona decrease mom's frequent, substantial, and qualitative parenting time?
Well, anytime dad gets more, mom gets less, so yes.
So the converse is also true?
Well, I mean, you can't split two apples into an apple, or one apple into two apples. So somebody's going to lose when the other person gets more. But the statute and this court and Smith and so forth, we start from that we want frequent and meaningful for both. So yes, mom's going to lose some time, but then the cross point is that to meet the statute, it's both parents get it, not just mom losing some.
All right, thank
I
you
know
so
I'm
much.
out of time.
All right. Mr. Murray?
Thank you, Your Honor. May it please the court, my name is Stanley David Murray, and I'm the attorney for the appellee Molly Windschill, who was the respondent in the lower court proceedings. I think I better advise the court that I have a 10:15 oral argument next door, so hopefully we won't run over time, but if I may be excused at 10:10, just
Where's
in
next
case.
door?
Across the hall, sir.
Oh,
That's federal court.
well, that'll be up to you.
I wish they could have kept it here, but such is the way the scheduling goes. I want to emphasize the standard of review that's applicable to this case. It's a relocation order and a parenting time order that this court is being asked to review. And the standard of review is abuse of discretion. Abuse of discretion occurs when the judge commits an error in the law, or doesn't pay attention to the evidence that's submitted, or the record fails to support the decision that the court made. Here, the court properly applied the law. In the relocation statute, the court went through all the factors under 25403 and 25408. The court paid attention to the evidence. It heard conflicting evidence from father about how he was daily involved in the kids' activities, whether contradicted that. When it comes to credibility, this court will defer to the trial court. So the findings under 25403 and the other disputed issues under 408 were carefully considered by the trial court.
What do you think of Mr. Berkshire's argument that the trial court failed to consider the fact that mother was willing to relocate to Arizona and that the court never considered what that parenting plan would look like?
Because that's not one of the factors under 408 or 403, Your Honor, when it comes to a relocation case. And it's a loaded question. It's kind of like, have you stopped beating your wife kind of question that they ask in these criminal cases. My client would be, damned if she did, if she said that she would stay, thereby showing that it wasn't in the kid's best interest to relocate. At the same time, she said that she was going to go to South Dakota and leave the kids here. Then obviously it's her best interest that she's talking about. So I don't think the question really has much merit or that it has any bearing on the factors that the court has to consider.
Thank you.
If you look at the 408 factors too, Mr. Berkshire talked about grandparent visitation. That's not what this case was about. Under those 408 factors, there's a review of what the child's relationship is with others besides just the parents, whether there's a support system there, and also the prospective advantage to the custodial parent or the children. So obviously having family members there that could take care of the kids in an emergency situation is of much better benefit than if the kids were here with father totally unable to take care of the kids.
Mr. Murray, just back to Judge Campbell's question, I think that part of Mr. Berkshire's point was that we have a lot of findings that, of course, we have to review under our standard about what the court did consider, but part of what Mr. Berkshire's complaint, I think, here is what the court didn't consider, and that is what the 408 factors in particular on the kids. There's a lot of information in the minute entry about what the kid's life would be like in South Dakota, but there's not much at all about what the scenario would be if they stayed. And the scenario that your client conceded to was that she would be in town, and therefore they would have a broader parenting time schedule. And we don't see a lot of information in the minute entry about what that scenario looks like for the kids.
Well, yes, we do, Your Honor. I disagree with Mr. Berkshire on that point, because father admitted he'd have limited time with the children. Mother would have to have daycare. Mother would have to work full-time. Those issues were discussed and considered.
Right, but the
by
kids
court.
had been in Arizona for a period of time before they went to South Dakota, correct?
That's
and
true.
so there was some sort of, and I assume that there was something the court could have talked about. Were they well adjusted here? We don't see anything in the minute entry about, South Dakota would be great, here are the reasons why, but in Arizona, they were stable. They had this, they had that, mother, yes, she'd have to work more, but whatever the case was, and I think that's part of what he's saying, is that you have to put one schedule against the other and show your work about why the South Dakota schedule is better, instead of just concluding that the South Dakota schedule is better. And here's my argument to buttress why I made this decision, but without considering the other side. And we're not really seeing that work. How should we look at that?
Well, that would have been father's burden, I would think, to show what the relationship would have been with the kids here in Arizona. And he failed in that regard because he had to
Well,
admit.
it's a finding the court has to make, though, about allowing a relocation. And I think Mr. Berkshire's point is that you can't make that decision when you're only looking at one side. And if we can't clearly see that the court has considered all the 408 factors in light of what if the alternate parenting schedule, which is they're in town and dad's seeing the kids 3 times a week, and we don't see a lot of how the kids would be, how the framing of their life would be if that were the case.
Okay. I think it was a given as to how often the father could see the kids if they were here in Arizona. He testified at the temporary orders hearing that he works 12-hour shifts 5 to 6 days a week. So let's say he works from 6 a.m. to 6 p.m. If he's going to see the kids, it's going to be for 2 hours probably, because I'm sure their bedtime was about 8 o'clock. So that's not a very good relationship with the children. And even when the children were here, mother gave examples of when father was too busy on the computer, couldn't even hug his child to say goodnight to him, didn't participate in any of the kids' activities. And again, mother contradicted his claim that he took care of those kids. That was all before the trial court. And that led into the factors under 408, actually 403, as to the children's relationship with the other parent. So I believe it was covered, and I've never seen a relocation case where the court had to list staying here factors versus going away relocating factors. The court has to go under 408, and it did that in this case.
Okay.
And then under the parenting time itself, Mr. Berkshire says it's substantial or it's continuous, but it's not frequent and meaningful. Well, again, under the scenario of father working 5 to 6 days a week at 12-hour shifts, I don't think he could have actually done 5 to 6 hours twice a week, let alone an overnight. With the schedule that he has...
But your summation is not a finding, though. I mean,
That's true.
that was his proposal, was that he could do that. And
But the trial court doubted that.
the court what?
I believe the trial court doubted that he could do that. And at the same time, the schedule that the judge did give, the parenting time, is not really long distance. The kids are here in Arizona, and they're not just anywhere in Arizona. They're in father's house 24 hours a day with a 7-day period that he has the kids. So there's a lot of contact there. Even though father works 12-hour shifts, I'm sure he's going to be seeing the kids when he comes home to rest. He could feed them at that point. He could take them outside for some activities, more so than this 5 to 6 hours that he's proposing, and the one overnight where he wouldn't really have much contact with the kids. So in conclusion, Your Honor, we have a situation where father had a choice in residency programs. He could have gone to South Dakota because at the time he chose to stay in Arizona to do his residency, the kids were already up in South Dakota. And when that residency is done, he's probably going to have to move again. He wants to find a fellowship. And I understand from the testimony from the trial, fellowships are not easy to get, so he might have to relocate it himself. During the week of the hearing, father had the whole week off, but never wanted to see the children after my client asked if he wanted to make arrangements for that. And the record shows that the children have now been living in South Dakota for 2 years. They're stable there. They're well thriving in South Dakota. And even though mother's working part-time, she has a lot of time to spend with the kids and is able to support herself, whereas the financial situation would be a lot more restrictive, as the evidence in the trial did show. So the trial court was balancing those two factors as to whether staying here would be better than relocating to South Dakota. So we're asking the court to affirm the decision made by the trial court, and we're requesting attorney's fees as well. And unless the court has any further questions for me,
Thank you. Any other questions? No. All right, I think we're good.
thanks. I'll be able to run to my next hearing.
Thank you both for your argument. We'll take the matter under advisement and issue our decision in due course, and the court is adjourned.